The Supreme Court today allowed an NGO named We the Citizens to approach the Union government with a plea seeking probe into the targeted killings of Kashmiri Pandits and Sikhs in Jammu and Kashmir back in 1990, which had led to their exodus from the valley. A bench comprising Justices B.R. Gavai and C.T. Ravikumar expressed disinclination to entertain the matter and instead asked the petitioner to approach the central government and raise their grievances before the government. Conceding to such a suggestion, the counsel appearing for the petitioner in this case sought liberty to withdraw the petition. The Supreme Court accordingly allowed the same and granted liberty to the petitioner to file a representation to the appropriate authorities and withdraw the petition. So what were the contentions of the petitioner in this particular case? The petition filed before the Supreme Court sought a direction to the government to conduct a census of those victims who were forced to flee the state and reside in different parts of the country. It was pointed out that the attacks on Kashmiri Pandits during the period between 1989 to 1990 was a genocide of the highest order with the intent to ethically cleanse the Kashmir Valley from Hindus and Sikhs. During the hearing today, the counsel appearing for the petitioner submitted that it was a genocide of more than 1 lakh Hindus in Kashmir. He relied on the study in the book Our Moon Has Blood Clots by Rahul Pandita, which described the first-hand account of murders, arson and migration of Hindus and Sikhs from the valley. He argued that the book contained detailed accounts of the incidents and that the author of the book himself was a victim of the attacks. Pertinently, the Supreme Court was apprised that the Jammu and Kashmir government had never investigated the alleged conspiracy and that the Indian Penal Code and the Code of Criminal Procedure were implemented in Jammu and Kashmir only in 2019 after the abrogation of its special status under Article 370 of the Constitution, as the Ranbir Penal Code was governing till then. Therefore, appropriate action under the penal statutes, that is the IPC and the CRPC, had not been taken with respect to the crimes. It was also highlighted that the attacks in 1990 were a glaring example of a complete failure of constitutional machinery in preventing the genocide and protecting the life and property of Kashmiri Hindus and Sikhs in the Kashmir Valley. Owing to this, the fundamental rights guaranteed under Articles 14, 19 and 21 of the Constitution of India were openly violated, it was contended further. It may be noted that back in March this year, Kashmiri Pandits organization Roots in Kashmir had filed a curative petition in the Supreme Court seeking a probe into the killings of Kashmiri Pandits during the height of militancy in the valley during the 1990s. This curative petition was filed against a 2017 verdict of the Supreme Court, which had dismissed the organization's petition for probe, citing long delay. Thank you. This is Aratrika Bhaumik for LiveLaw. Keep watching LiveLaw for more such updates.